Good evening from New York. I'm Chris Hayes. Donald Trump is facing many trials in this election year, or at least cases that could potentially go to trial. We're going to see if he faces trials. We have news on one of them tonight. In the Mar-a-Lago classified documents case, special counsel Jack Smith is, as of just a few hours ago, proposing to the federal court in Florida that trial should start on July 8th. Trump's attorneys are suggesting a trial should start in 2025 after the election, if at all, according to court filings. The judge appointed by Trump in the lame duck session in 2020 may make a decision on that tomorrow. We will watch carefully for that. But whatever she decides, that trial date will then have to go through a legal gauntlet, possibly going up to, you guessed it, the Supreme Court, based on, you guessed it again, another immunity assertion that Trump is now making in that case, even though the crime he committed was not when he was president. Now, how quickly will all that move? Well, you see, here's the thing. What the Supreme Court has going for it as an institution by constitutional design is that it is insulated from electoral politics intentionally. I mean, we give the justices lifetime tenure in large part to ensure their interpretations of the law are not subject to the whims and the passions of pundits and politicians and parties and even majorities of voters. But that independence is a two-sided coin. On the flip side comes a danger deep within the court's design that its independence tips over into a kind of reckless lack of accountability. And one way in which the Supreme Court of the United States is just completely unaccountable is on the basic question of what it does and when it does it. With a few exceptions, like disputes between two different states over water rights and stuff like that, the court only takes the cases they want to take. They reject the ones they don't want. The court can adhere to normal procedure when they want to, and then they could completely break normal procedure whenever they want to. When they want to act fast, they can act very fast. When they want to slow walk something, they can go very slow. Yesterday's one-page announcement that after 2.5 weeks of doing Lord knows what, they were scheduling arguments on Donald Trump's claim of presidential immunity from prosecution for 7 weeks from now seems to indicate that a conservative majority of the court does not want to move particularly quickly. And I would hazard that part of that reason is that to move quickly would mean Donald Trump would face an imminent trial for the insurrection he fomented. And that would, I think, appreciably hurt his chances of being the next president. But if the Supreme Court justices wanted to move quickly, they definitely could. Let me give you a little recent context for this, because I think it's important and it can get lost in the procedural weeds. So back in December, Donald Trump filed a claim saying he was immune from prosecution for trying to overturn the election because he was being charged for acts he committed while he was president. And the district judge in that case, Tanya Chutkan, heard arguments and issued a very well-reasoned ruling saying, no, buddy, it doesn't work that way. Quote, whatever immunities a sitting president may enjoy, the United States has only one chief executive at a time, and that position does not confer a lifelong get-out-of-jail-free pass. And then the special counsel prosecuting the case, Jack Smith, did something a little novel and even audacious. Rather than waiting for Donald Trump to appeal that ruling to the D.C. Circuit, which is the next step up the ladder, Smith said, hey, we all know this is going to end up in the Supreme Court. Let's just go to the Supreme Court now. Let's do it. Let's have it out. And he applied for this somewhat rare procedural mechanism that's called cert before judgment. And what it means is that you basically leapfrog a step. You leapfrog the appellate court and you rush straight to the doors of the Supreme Court to save time in this case, and also because you know it's going to end up there. And when he tried to do that, the Supreme Court responded, no, cool your jets. We're going to let the appeals run their course first. So now, of course, another 2 months have gone by. The appellate court has ruled unanimously against Trump. They'd issued their own very strong unanimous opinion and then petitioned back up to the Supreme Court. And what does the Supreme Court do in response? They say, you know what? Actually, check that. We do want to hear the case 7 weeks from now. So the court succeeded in burning more than 3 months off the calendar. And I want to be clear here. It's not just that they could have gone faster. It is that on other recent cases, they have shown themselves extremely ready to jump in and snatch issues from the lower courts when it suits them. For instance, when President Joe Biden issued an executive order that would have canceled literally hundreds of billions of dollars in student debt for millions of our fellow Americans, a bunch of Republican states sued to stop the plan. They lost their lawsuit at the district level and they appealed. And then you know what happened? The Supreme Court stepped in and they granted cert before judgment, same thing Jack Smith wanted, to leapfrog the appellate court and take up the case on an expedited basis. Now, was there something particularly pressing about this case, other than the notion that millions of American students would have their debt canceled? Not really. I mean, it wasn't like a death row appeal. But sure enough, look at that. The court just could not wait. They couldn't move fast enough. They came together with a conservative majority on incredibly novel legal reasoning, and they snatched back that debt cancellation to make sure that students would have to pay every cent of their student loans. They could not move fast enough to make sure no one got their debt canceled. They were in a real hurry on that one. Same process played out in August of 2021. President Biden wanted to extend the Trump administration's pandemic moratorium on evictions. So in the midst of a once-in-a-century pandemic, you don't boot people with their stuff out onto the street. Landlords and realtors challenged it. And while it was before an appellate court, they petitioned the Supreme Court for immediate relief. They said, we don't want to wait. We want to jump the line. We want to go to the straight Supreme Court. Just over 3 weeks after Biden ordered the eviction ban, the 6 conservative justices of the Supreme Court sprang into action, quickly deciding the moratorium could not stand, that yes, you can throw people out of their homes. 3 weeks. They had to do whatever it took. Burn the midnight oil, feed the clerks extra helpings of Red Bull to make sure people could start being evicted again. Those are just 2 of the examples on this court in recent memory. But it's also clearly the case through American history. The court can and does move very quickly on high-profile cases with national political significance. We talked about this case a lot yesterday. You know it, you love it. U.S. v. Nixon, the infamous case in which Richard Nixon refused to hand tape recordings from the Oval Office over to a federal judge in the Watergate scandal. Everyone in the country understood this was make or break for Nixon. It was the biggest case of the time. Those tapes could prove his involvement in crimes. And on July 8th, 1974, the Supreme Court heard arguments in the case when they weren't even in a regular session.
A decision is expected in a week or two. Even before this morning's argument, one justice was writing and circulating his ideas. Another had his clerk prepare a draft opinion.
With the fate of the Republic on the line, the court issued their decision just 16 days later.
President Nixon has not yet responded to the sledgehammer decision of the Supreme Court today, which ruled that he must immediately turn over tapes of 64 presidential conversations.
What about Bush v. Gore? Remember that one? 2000 election, the recount in Florida? Barely a month after the votes were cast, and one day after Florida's highest court ordered a statewide recount, the Supreme Court stepped in. They granted the Bush campaign an emergency stay to stop Florida from counting the votes. Do not count any more votes. The reason that Bush wanted that was that the Bush campaign was worried that if the recount continued, Al Gore would pull ahead. And then one day after granting cert in one of the most expedited cases of all time, the conservative court took oral arguments and began deliberating quickly.
It doesn't get any more tense than this. The justices working for a second night on their historic decision.
All this waiting for a decision in a case that was, after all, argued only yesterday.
The justices seem determined to rule on this case quickly, well aware of the coming deadlines for choosing presidential electors.
Just 4 days after granting their initial stay, by a single vote, the High Court permanently stopped the recount and gifted George W. Bush a presidential victory. So when it comes to making sure that a presidential Republican candidate for president gets into office, man, the Supreme Court can really move at the speed of light, can't they? The point here is that even though this conservative court seemingly tipped their hand this month by sitting on the Trump case for 2 weeks and then scheduling it for arguments way down the line on April 22nd, they can still, if they want to, move very quickly. It is still in their power. And no one should let them off the hook on this massively important and weighty question before the nation. Will the man who tried to overthrow the constitutional republic face a trial for those alleged crimes, or will he not? 9 Americans can still decide that Donald Trump deserves to stand trial, to present evidence under our Constitution before a jury of his peers to find out whether he is guilty or he is innocent of what he is charged before hundreds of millions of Americans go into a voting booth and see Trump's name on their ballot.